Hello, and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. You may have seen in the news recently that a police officer by the name of Richard Sr. was found guilty of a number of corruption-related offenses. Now, I'm going to be covering that decision, but it's 188 pages, so that's going to take a while to distill down to the key bits without sort of losing the main element. However, I've found a case that is a bit of an appetizer to that one because it mentions Mr. Sr., so that is the case of the Queen and Caterina Petrollo. Let's have a look at this case. It's all tied together. These are all interconnected. So, introduction. Caterina Petrollo has been charged with one count of breach of trust by a public officer, contrary to Section 122 of the Criminal Code, and one count of attempt to obstruct, pervert, or defeat the course of justice, contrary to Section 139 sub 2 of the Criminal Code. Both offenses were alleged to have occurred at the city of Markham between May 25th and October 9th, 2018. The charges against Ms. Petrollo stem from her employment as a York Region Paralegal Regional Prosecutor and her involvement in Provincial Offences Act prosecutions. So that'll be mostly traffic tickets, but probably not exclusively. It is alleged that she used her position to improperly influence the outcome of provincial offences matters. To be more specific, it's alleged that Mr. Sr. suggested that she sort of fix tickets for some people. Let's continue on to see how this takes place. She only came to be investigated by York Regional Police after tangentially becoming a person of interest in a multi-jurisdictional investigation into police corruption. Police Officer Richard Sr. was its originating and primary target. York Regional Police obtained judicial authorizations which led to them intercepting communications between Ms. Petrollo and Mr. Sr., wherein dispositions in Provincial Offences Act matters of individuals known to him were discussed. So what this means is that they got a wiretap on Mr. Sr. And because they had that wiretap on Mr. Sr., when he was communicating with Ms. Petrollo, they picked up on those. And because those communications were being listened to and, otherwise observed by officers, when they heard that there was some other sort of shady stuff going on, they took an interest. So because Mr. Sr. was under the microscope, that's how they came to find Ms. Petrollo. So they've got some details here about how they passed this along. But once they sort of found this, they pulled her records for what she was doing in court, and just so that they could see, because when they talk about fixing a ticket, they want to see what actually happened with that ticket. Did this actually occur? So, breach of trust. Section 122 of the Criminal Code provides that every official who, in connection with the duties of his office, commits fraud or a breach of trust is guilty of an indictable offense and liable to imprisonment for a term not exceeding 5 years, whether or not the fraud or breach of trust would be an offense if it were committed in relation to a private person. And they note that there's a number of elements here. So element 1, the accused is an official. Element 2, the accused was acting in connection with the duties of her office. 3, the accused breached the standard of responsibility and conduct demanded of her by the nature of the office. 4, the conduct of the accused represented a serious and marked departure from the standards expected of an individual in the accused position of public trust. And 5, the accused acted with the intention to use her public office for a purpose other than the public good, for example, for a dishonest, partial, corrupt, or oppressive purpose. So there's a whole bunch here. We can see there's standards of care here, the standard of responsibility and conduct, and it has to be a serious and marked departure. So it can't just be a little bit over. It's not that this is kind of a red line. You have to have stepped over it substantially. How much so? Well, that's ultimately a question for the court. The court, in fact, has to be satisfied beyond a reasonable doubt that it's a serious and marked departure. So most of the gray area goes towards the defense on that. But when we see the standards expected of an individual in the accused position of public trust, those are usually high standards. We expect a lot out of prosecutors. We expect a lot out of police, at least in theory. We should expect a lot out of both police and prosecutors. So the court is likely going to view that as a fairly high standard. And the accused acted with the intention to use their public office for a purpose other than the public good. So that is, if they're trying to accomplish some public goal, and that would be, consistent with their office, then that would also be a defense. So they also note that there's no issue that Ms. Petrollo is an official and that she was acting in connection with the duties of her office. The remaining elements are all an issue here. So I'm sure that the defense conceded those points because obviously she was a prosecutor. So Crown Counsel's theory of the case is that Ms. Petrollo intervened in Provincial Offences Act prosecutions and arranged for favorable dispositions because of the defendant's relationship to Richard Sr. and Mr. Sr.'s relationship with Ms. Petrollo. Her actions were motivated by partiality or favoritism. It was an agreed fact that before and during the relevant time, Ms. Petrollo had a romantic sexual relationship with Richard Sr., who was married. So that sort of sets the stage of what's happening here. I'm going to be skipping over quite a bit in this case because this case is really an appetizer for the next one I'm going to be covering, not the main dish. But also, it'll otherwise be a little long. I will link this case in the description below, so you can, of course, check it out if you want to see the bits that I've skipped over. So counsel for Ms. Petrollo countered that partiality and favoritism played no part in anything that Ms. Petrollo did. Any disposition of charges arranged by her were consistent with what she or any other prosecutor might do for any defendant. Now, this is kind of an important thing because the courts are slammed, would be a good way to put it. There are more cases going through the courts than anybody could possibly hope to run trials for. So it is essential that things get resolved. Prosecutors offer deals because that makes it easier for the court process to go. If, in fact, everyone ran a trial, things would grind to a halt. So they're saying, listen, sure, some people got deals, but we do that all the time. This is not a big deal. This is not anything unusual or special. Anybody could have gotten these deals. So what's the issue? Attempt to obstruct justice. Section 139 sub 2 of the Criminal Code provides that every person who intentionally attempts in any manner other than the manner described in subsection 1 to obstruct, pervert, or defeat the course of justice is guilty of an indictable offense and liable to imprisonment for a term of not more than 10 years. And they note that sections 1 and 3 don't apply here. In Yarlaski, the Ontario Court of Appeal stated that the essential elements for a conviction on a charge of obstruction are 1. That the accused must have done enough for there to be a risk, without further action by her, that injustice will result, and 2, the attempt by the accused to obstruct justice must have been willful, so not something accidental or something like that. Note that it's only a risk that injustice will result, and it has to get to a point where that risk already exists. It's not enough for this to be part of a pattern where there'd be that risk further down the road. It has to have gotten to the point where that risk exists. And they're going to be quoting a bit from a case, Baudry, which involves a police officer who was charged with obstructing justice. The allegation was that he intentionally screwed up on an investigation, and then ultimately he was convicted of that. So they say the following comments by the Supreme Court are therefore applicable here. An accused cannot be convicted of the offense provided for in section 139 sub 2 solely because she has exercised her discretion improperly. Where discretionary power is relied upon, the analysis of the actus reus, that's the guilty act. So there's two elements to any criminal offense. There's the guilty act and the guilty mind element. So this is the act itself of the offense must be carried out in two stages. First, it must be determined whether the conduct in issue can be regarded as a proper exercise of police discretion, or in this case, prosecutorial discretion. If so, there is no need to go any further. If beyond a reasonable doubt the conduct in issue cannot constitute a proper exercise of police discretion, the analysis must be pursued further. Second, the actus reus of the offense will be established only if the act tended to defeat or obstruct the course of justice. With respect to mens rea, this is a specific intent offense. The prosecution must prove beyond a reasonable doubt that the accused did in fact intend to act in a way tending to obstruct, pervert, or defeat the course of justice. A simple error of judgment will not be enough. An accused who acted in good faith but whose conduct cannot be characterized as a legitimate exercise of discretion has not committed the criminal offense of obstructing justice. So this doesn't cover screw-ups. It doesn't cover somebody who just made a mistake. This has to be an intentional act, and it has to be an intentional act that simply can't be reconciled with sort of the ordinary process. So, as with the breach of trust charge, Crown Counsel's theory of the case is that Ms. Petrolo intervened in Provincial Offences Act prosecutions and arranged for favorable dispositions because of the defendant's relationship to Richard Sr. and Mr. Sr.'s relationship with Ms. Petrolo. She gave the defendants preferential treatment because of those relationships. Counsel for Ms. Petrolo again countered that partiality and favoritism played no part in anything that Ms. Petrolo did. Any disposition of charges arranged by her was consistent with what she and any other prosecutor might do for any defendant. So, same real argument on both sets of charges. Crown says, listen, he's pulling strings for her, that's improper. And defense says, no, this is just how court works. So, facts of the alleged offenses. Ms. Petrolo is charged with one count for each of the alleged offenses. However, Crown Counsel is relying on 4 separate events. The Carlton Wills event can be broken down further into 2 separate sub-events. Each of these events or sub-events could have been the basis for a separate charge. Instead, Crown Counsel is simply asking me to convict Ms. Petrolo of the 2 counts before me if I'm satisfied beyond reasonable doubt that any one or more of the events constitute an offense. So this is not improper here. The Crown could have proceeded and laid a separate charge for each thing, and that would have been a whole lot of counts. But they can also lay sort of one charge to say this offense happened in these events somewhere. So if you think about it, another situation where this comes up is when somebody steals mail. So let's say somebody goes to a mailbox and steals a big bag of mail, and you catch them with it. They don't make it half a block before a police officer who saw the whole thing tackles them, they go in. You can theoretically charge them with a separate count of theft for each individual letter. However, that might be kind of a waste of time. There's a whole lot of reasons why you might not do that. So instead, the police might just charge them with theft of mail in general. And that person might be able to say, hey, listen, one of those letters is mine. That's addressed to me. I'm entitled to possess that letter. In which case, you wouldn't care about that thing. But if they're charged with theft of the mail generally, so long as any of that mail was stolen, you can make out the charge there. So that's kind of what's going on here, more or less. So I'm satisfied that I must look at each of these events separately. Crown Counsel did not bring a similar act discreditable conduct application in this case. When questioned by me, he made it clear he was asking me to rely on evidence relating to all events in my assessment of all events. He argued that he did not need to bring a formal application. I disagree. So let's talk about what's going on here. What is similar act evidence or discreditable conduct evidence? Well, there's kind of 2 ways this works. The first way is that it might apply to identity. So let's say you've got a very unusual crime. So somebody, for instance, is out robbing people. They're, sticking them up in a park, and it's always the same park. And further, they're always doing it wearing a clown mask. So far, so good, but we can get even more specific. Let's say they're always described as using a machete, which is noted to have a particular notch on the blade. Everybody points out this notch on the blade. And further, that this person is always described as singing Frère Jacques before they commit the robbery. Now, at this point, we're talking about a very specific sort of robber. It's very unlikely that there's more than one person using that same MO. And so, assuming that it hasn't been reported in the news, because if it's been reported in the news, that might undermine this. You might get copycats. But if nobody in the public has heard of this, if this is something, that's unique to this particular person, what you might have is 4 or 5 people who have complained that they've been robbed by somebody who's been doing this. And then on the 6th time, the police actually just happen to walk in on the robbery as it's happening. They tackle the person, they pull off the mask, and it's, Old Man Jenkins or whoever it is who's committing this. And so they get that person, they've ID'd them, but now they want to charge them with all the other robberies. Of course, the defense is going to say, well, sure, you got me on this one. You caught me right in the middle of it. But who knows who it was in all those other, situations? I mean, he was wearing a mask during them. So what the Crown is going to say is, listen, this is such a unique set of things that we can infer based on that it was probably the same person in those other ones. So that would be sort of a similar act identity issue. But you can also get to sort of discreditable conduct situations in where this might be relevant. Now, this is kind of a tough bar because normally the rule is that you can't say just because you did one bad thing that you probably did another bad thing. But there's circumstances that may kind of lead to it. Let's say, for example, you are running a gym and you are the gym owner, and every night they've caught you on camera repeatedly, and they've been investigating this for some time. When people go to your gym, you go through the locker room and you steal stuff that is left behind and you sell it on Kijiji. And so all that stuff gets stolen and sold and out it goes, or whichever sort of online marketplace. But so they then find you later and you've got somebody's wallet and somebody else's boots and whatever else. And that time your argument is, well, I wasn't going to sell these items. These items I was going to put in a lost and found. They might say, listen, every other day for the past, 3 months, you've gone through and you've taken all this stuff and sold it. We can infer that that's probably what you're doing on this occasion. So that's that sort of gets us to establishing what you are planning on doing with that wallet. So essentially what the Crown is trying to do here is trying to say, listen, there's bad acts going on some of them, and the other facts are very similar, so we should conclude that those other facts involve bad actions. And the court is not having it, as you can see with the I disagree. So let's go through the reasons why the court is not going to have it here. So they say the general rule is one of presumptive inadmissibility. So as a starting point, you can't tender this stuff. It's out until and unless the court is convinced otherwise that it should be admitted. Evidence of an accused's discreditable conduct is inadmissible unless that conduct is the subject matter of the charge in question. In multi-count indictments, already admissible evidence can be used only on the count to which it relates. Before that evidence can be used to prove guilt on another count, the Crown should bring an application and the trial judge conduct an admissibility inquiry. In this way, the defense has a meaningful opportunity to respond to the use of the evidence across counts, and no prejudice will have occurred. So essentially, defense should be put on notice that this is happening, and they should be able to argue against it. It shouldn't just be after the trial is done that you say, oh, by the way, now I want to use that evidence in this fashion. So this is a fairness issue. However, while it is an error for a trial judge to rely on a cross-count prior discreditable conduct in the absence of a Crown application, that error is not necessarily fatal. What they mean by that is that sometimes the appellate courts don't reverse a lower court decision where that error has been made. So none of this is particularly new, but I found the review of the existing law to be timely. They're talking about a specific case there. Taking a principled approach, I see no reason to distinguish between using evidence across counts and using evidence across events. So, continuing on here, Crown Counsel has proposed that the evidence of other discreditable conduct be admitted because of the objective improbability of coincidence. So again, that's sort of what I'm talking about before of the uniqueness here. So I must, however, keep in mind that it is not enough for Crown Counsel to simply propose that the evidence be introduced for the previously enumerated purpose. Let's continue on, and they're going to look at several events. I'm going to just look at one of them because this is kind of one of the most important ones. There's several others. If you're interested, again, I'm linking the case so you can go check out the other ones. But this one has also kind of the strongest tie-in to the next case. So Carlton Wills. Mr. Carlton Wills is the father of Fabian Wills. Remember that name. It may come up later. There will not be a test because that's not how I roll, but it may come up later. Richard Sr. grew up with Fabian. Their friendship spanned 30 years. Carlton Wills testified that Mr. Sr. was like a son to him and called him Pop. Carlton Wills did not know Ms. Petrolo. Fabian Wills did know her. Carlton Wills received 2 traffic tickets on separate days. One was for the offense of disobey sign. This occurred in Markham in the region of York. The second ticket was for failing to wear a seatbelt. This occurred in the city of Toronto. I will deal with each of these 2 tickets separately. After receiving the York Region tickets, Mr. Wills spoke to Richard Sr. and asked what he, Mr. Wills, could do about it. Mr. Sr. told him to set a court date. Mr. Wills did this himself. He did not hire anyone to help him or to act for him. So quite commonly, people will hire people to help them with tickets, but also quite commonly, people appear on their own. So both happen all the time. Mr. Wills received a letter telling him when the date was. A week to 10 days before that date, he received a call telling him not to attend. A transcript of proceedings on June 1st, 2018 in the Provincial Offences Court at Richmond Hill lists Mr. Wills as appearing in person. The transcript also shows that Municipal Prosecutor Ms. B. Hammond stated to the court, "I ask that the matter be marked withdrawn." It was withdrawn. So withdrawn is when the Crown asks that it be essentially pulled back, and so there's no conviction, there's no anything. Now, it's not quite as good as an acquittal. In theory, it can be relayed later, but in this case, it's unlikely that that's going to happen, so the charge just goes away. So there are no court documents connecting Ms. Petrollo to this. The Crown relies instead on intercepted communications to implicate her. And we see no court documents connecting her because it was a Ms. B. Hammond. And just to be clear, there is no suggestion that Ms. B. Hammond did anything wrong here. There's no indication of that in the file, so much as she's named here, don't draw any conclusions on that. So there are no court documents connecting Ms. Petrollo to this. The Crown relies instead on intercepted communications to implicate her. The following is a summary of an intercepted WhatsApp chat dated June 1st, 2018, involving Ms. Petrollo, CP, Fabian Wills, FW, and Richard Sr., RS. The chat occurs between 11:51 a.m. and 11:59 a.m. Now, I'm guessing that they gave Ms. Petrollo CP because of Crown Prosecutor, but that's a really unfortunate set of initials there. I hope YouTube doesn't get too eager with their sort of auto detection algorithms. Otherwise, this one will go to manual review. So let's continue on. CP, hello. Fabian, LMAO. CP, Fabian, your father's disobey sign tickets gone by emoji, which is probably a waving emoji, but who knows. Well, hello. And CP, CP says, I'm still sweating emoji. Maybe a sweat drip emoji? I don't know. We don't have it in this transcript. Fabian, oh my God, you are too good to me and my pops. He wants to meet you. CP, lol, he owes me a drink. No, he owes you a full bottle. Then photo of a document. Since everyone is in a good mood, you remember Miles Drake from LA Fitness? Yes, I remember. Young black kid. I know him. Don't forget to breathe as you sweat. Lol. I'm officially shutting down the CP Let's Make a Deal office after this. Rich, your tab is getting big. And he says, lol. I'm sure CP will assist where she can with Miles, but this chat group is solely Wills and their traffic stupidity. Yes, I agree, Fabian. Then the name should reflect that. And then LMAO, Wills Ticket Specialist. What you and her do in your spare time is not my business. Emoji. LMAO, haha. Rich, knock on wood, I've been clean for 4 years before the Speedy Gonzalez move. Be somewhat proud of your boy, and clean since. He says, lol, amazed, I'm amazed. Speed is in your blood. And then, lol. Following this, Ms. Petrollo changed the subject of the chat to Wills Ticket Specialist. After that, the following chat took place between 1:15 p.m. and 2:17 p.m. CP, drum roll, please. Fabian, please tell your dad his seatbelt ticket was withdrawn. Total saving of 4 points and $350. I'm guessing the 4 points is actually worth a lot more than the $350, although I am not super familiar with Ontario's insurance system, but usually points end up costing you more than the dollars. And they note that the screenshot of the chat lists her as Carl YRP, which was noted as being agreed as being Ms. Petrollo. So, lucky man. FML, I am feeling jealous. Lol, now he needs to keep that record squeaky clean. And please make sure he doesn't attend that June court date. Counsel for Ms. Petrollo argued that these communications do not support a finding of guilt. He repeatedly described Ms. Petrollo's comments as bravado and argued that these comments clearly show her trying to ingratiate herself, make herself more important to Mr. Senior, the man with whom she had a relationship. What she had done for Carlton Wills was simply what she or any other prosecutor would have done for any defendant in any other similar case. Her intercepted communications with Fabian Wills and Mr. Senior were an attempt to make it appear to be something more. Now, I'm going to stop them right there because most prosecutors would not want to have any sort of, side chat via a sort of private communication mechanism about this. So that in and of itself is unusual. So the court goes on to say, I disagree. I kind of love in the writing here, I like the writing style with just the flat, I disagree. It's a writing sort of stylistic element that we've seen on several points, but I think it's powerful writing. So there is no direct evidence before me to support the suggestion that this was an attempt to ingratiate herself with Mr. Senior. Ms. Petrollo did not testify. I'm aware of the fact that she did not have to testify, but I can and do note that she did not tell me what she meant by her comments contained in the intercepted communications. So let's talk about not testifying in court, because you have a right not to testify in court. However, and when you decide not to testify in court, the court can't hold that against you. They can't say, well, listen, if you weren't guilty, you would have testified, so we're going to make a finding, again, can't do that. That's absolutely forbidden reasoning. An appeals court would have a field day with that sort of reasoning. However, when you don't testify, your evidence doesn't get heard. And if the reason why you might not choose to testify, or one reason, is, first, it's stressful. So you might just not want to deal with the stress if you don't have to. But second, once you decide you want to testify, you can be cross-examined, and they can ask you all sorts of things, including things that might incriminate yourself. In Canada, your decision is, do you want to get up on the stand or not? You can't later say, well, that question would incriminate me, so I'm not going to answer that one. So this is a very important distinction. However, the court is pointing out, listen, we've got these submissions as to what her statements meant. But we don't have any evidence on that because she didn't tell us. So we can't just decide that this evidence exists in the absence of actually hearing the evidence. So there's also no basis for me to conclude that what she had done for Carlton Wills was simply what she would have done for any defendant in any other similar case. Again, this is the sort of thing she might have been able to tell the court, but if she doesn't tell the court that, then it's not evidence. The evidence before me makes it clear that the dockets in Provincial Offences Court are outrageously long, and that there's no way the court could accommodate even a small percentage of cases going to trial. Guilty pleas are essential. People plead guilty when offered deals. As a result, all prosecutors agree to deals so regularly that they've become the norm rather than the exception. But Mr. Wills got the ultimate deal. The charge against him was withdrawn. He paid no fine. He acquired no demerit points. He ended up with no blemish on his driving record. He did not have to hire and pay anyone to accomplish all of this. All he had to do was speak to his friend Richard Senior, who then apparently spoke to his friend Ms. Petrollo. That is where Ms. Petrollo should have communicated to Mr. Wills and Fabian that they should hire a paralegal agent or appear in person and talk to another prosecutor who would likely agree to some sort of deal, but that she could not agree to any such deal with him because of their personal relationship. So, hey, I got a conflict of interest. Please don't put me in a conflict of interest. Go and deal with this on your own, but I can't help you. I can't step in. That would have been the appropriate thing to do. Another possibility, albeit a less preferable one, would have been for her to ask a colleague to look at the case. I cannot deal with this. Could you take a look at it and see what would be an appropriate disposition? This would, of course, require care on the part of Ms. Petrollo to ensure that this would not be taken by the colleague as a request for a particular disposition to be agreed to simply as a favor to Ms. Petrollo. So they gave some sort of sample language there. I can't deal with this. Can you take a look at it, see what you want to do? That's fine. Nobody's going to give anybody grief over that. But you can imagine some less fine language. Hey, this person is a family friend, so I can't do anything with it myself, but see if maybe you could cut them a break, is not fine language. So that would also be a way to get yourself into trouble. Whichever way she proceeded, the outcome for Mr. Wills should have been the same if what Ms. Petrollo had done for him was simply what she or any other prosecutor would have done for any defendant in any other similar case. But Ms. Petrollo did not choose to proceed in either fashion. Now, this bit is a little understated bomb in this particular decision, because, of course, this is exactly the issue. If it would have been the same for Mr. Wills either way, why not just pass it on to someone else? Why not do that? The obvious conclusion is that it would not have been the same for Mr. Wills, that her involvement was necessary. That's what the court's getting at here. And I think this is a very sort of cutting way of getting exactly to the point. So I always approve of very clever language and very clever reasoning in court decisions. I like seeing court decisions that are well reasoned. I love seeing it when they just kind of cut through things to get to the heart of the issue. Instead, she arranged for the charge to be withdrawn. She was still sweating as she reported the results she had brought about. And why would she be sweating if it was just an ordinary thing, right? She told Fabian, "He owes me." I do not take this to mean he owed her anything in a material sense. So the court is saying, we don't think she's actually, getting a $50 payout or anything here. I do take it to mean that he owed her his gratitude because she had done a favor for him. Why was he so fortunate? There is no evidence to suggest that there was no reasonable prospect of conviction. Again, that would have been something she might have testified to. There is no evidence that prosecution was not in the public interest. Again, she might have testified to that if that was the case. There is no evidence of any compassionate grounds for special treatment. There is no evidence of any legitimate reason for the charge to be withdrawn. There is compelling evidence in the form of the intercepted communication that the charge was withdrawn as a favor to the friend of her friend. Ms. Petrollo's comments to Mr. Senior were not bravado taking credit for something she would have done for anyone. Ms. Petrollo did plenty for Mr. Wills, and her comments to Mr. Senior were her legitimate claim to credit for her illegitimate acts. Really nicely phrased there. So after considering all of the above, I am satisfied beyond a reasonable doubt that Ms. Petrollo, 1, breached the standard of responsibility and conduct demanded of her by nature of her office, and that her conduct represented a serious and marked departure from the standard expected of an individual in her position of public trust, and 3, she acted with the intention to use her public office for a partial purpose. I am therefore satisfied beyond a reasonable doubt that she committed the offense of breach of trust contrary to Section 122 of the Criminal Code. I am also satisfied beyond a reasonable doubt that, 1, Ms. Petrollo breached her duty by giving preferential treatment to Mr. Wills because he was a friend. 2, this was not a proper exercise of prosecutorial discretion. 3, her acts tended to defeat or obstruct the course of justice. And 4, she intended to act in a way tending to obstruct, pervert, or defeat the course of justice. I am therefore satisfied beyond a reasonable doubt that she committed the offense of attempt to obstruct justice contrary to Section 139, sub 2 of the Criminal Code. I point out here that I reached these conclusions without considering any of the other events. I also did not consider the facts surrounding the Toronto charge or the portion of the intercepted communication where the resolution of that charge was discussed. I found it unnecessary to consider anything beyond the facts surrounding this specific event. So going back to that discreditable conduct application, right? Or non-application. With regard to the traffic ticket in Toronto, Mr. Wills did much the same things as before. He went to court and set a trial date. Again, he was notified not to attend. He was told that the ticket had been taken care of. He did not attend. He did nothing to bring this about. He did not retain an agent to act for him. A transcript of the proceedings in Provincial Offences Court in Toronto on May 31st, 2018, lists an agent appearing for Mr. Wills. The municipal prosecutor is shown to state, Court's indulgence, 11/19/41, still no response, 158, asked that this matter be withdrawn, lack of evidence. Crown Counsel agreed that Ms. Petrollo was not connected in any way with the prosecutor's office in Toronto. She had no authority in the Provincial Offences Court in that city. Crown Counsel asked me to infer that she was involved in this event based on her involvement in the other events. So this is where they're getting into the discreditable conduct thing, right? I'm not prepared to do this for a number of reasons. Firstly, as I stated earlier, I'm satisfied that Crown Counsel should have brought a formal application to introduce similar act evidence. They did not do this, and that should be the end of this. If I am wrong, and I should have allowed counsel to make an informal application, I'm not satisfied that the probative value, that's the value that would lead towards a conviction of such evidence would, or not necessarily a conviction. Probative value is just the value of this in terms of getting the court to a right decision, would have outweighed its even limited prejudicial effect. Prejudicial effect is where something will tend to steer us away from a correct decision by biasing the court in some fashion. So, if you imagine, for instance, somebody who's charged with a murder and, the Crown wants to introduce evidence that this person has a hobby of kicking kittens. Well, that may not actually point to them as the murderer, but if you're putting this in front of a jury and they hear, oh, this guy likes kicking kittens, they're probably going to think this guy's a murderer. It's a strong prejudicial effect. They want to find against him because now they don't like him and they think he's a bad person. And because he's a bad person, he might do bad things, but it doesn't actually tell us if he did this murder. So that is sort of an example. It's kind of a ridiculous example, but ridiculous examples are often good ways to illustrate the underlying sort of logic and concepts. And they tend to be more fun than more down-to-earth examples. Now, I just kind of want to comment on this because the Crown actually does better by losing on this similar fact evidence or discreditable conduct evidence than they would have by winning. The reason why is because if this were to go to appeal, and it doesn't look like this did, but if this case were to have gone to appeal, it would have been much easier to appeal on the ground of the finding of discreditable conduct, if that was something that the judge had relied on. However, where in this case the judge says, no, I'm not granting that, but I can still convict based on what I've got here. I don't need that. I can just convict here. That whole argument is eliminated. The defense can't appeal this on the basis of that ruling on the discreditable conduct because they won. Had the Crown won this, that might have opened up a ground of appeal that might have opened up for an entirely new trial. Sometimes it's better to win narrowly than it is to win all the way. So it's kind of an interesting sort of fact of our justice system, but the Crown losing this application actually helps them at the end when we're looking at the verdict. So that's always something I find interesting and maybe isn't something that non-lawyers think about. I don't know. So that is sort of the first thing. There's a number of other kinds of events here where there were other tickets kind of dealt with. I'm going to skip over all of that. You can read it if you want. There's a whole lot going on in this, but conclusion, based on my findings with respect to the Guarino event, which I skipped over, and the first Wills event, I'm satisfied beyond reasonable doubt that Ms. Petrolo committed both offenses, and I find her guilty of both. And that was January 17th, 2020. So what we can see here is there was that wiretap, and it's all interconnected because, that wiretap gets them to finding what's going on here. It gets them to finding Ms. Petrolo, and then she's stuck. So, she wasn't even on their radar. She just happened to be kind of caught up in all of that. Now, you might be inclined to say, and, I kind of have some sympathy for the argument of, hey, who cares? These are just traffic tickets, and, they give too many traffic tickets anyway. They tend to overcharge things. Isn't it okay if those tickets just went away? The problem with this is that tickets should go away or not go away based on sort of fundamental principles. If we think that there's too many tickets being written out, then they should write fewer tickets or remove tickets for lots of people. It shouldn't be a matter of who you know and how connected they are. You should approach the justice system, and you should walk into a courtroom the same if you have friends in high places versus if you have friends in low places versus if you have no friends at all. And I know that's a naive and lofty ideal, but it's one I think we should strive towards. So this isn't a situation where we have sort of a clear victim. Certainly, the people whose tickets went away aren't going to be saying, listen, I was harmed here. I was wronged. I want you to fix this. Write me a new ticket. I can guarantee you, none of them contacted the Crown Prosecutor's office and said, is there any way you could just write me that ticket again? I'd really like to end up paying that. I'd love those demerit points on my license. Yeah, I'm being silly here. But the offense here is really one against the administration of justice. And it's important to root out these kinds of side deals wherever we can. Sadly, that's probably going to be hard because in most cases, people's phones aren't being wiretapped for obvious reasons. Police officers enjoy a right to privacy, same as you or I. They are citizens. The same rights apply to them. So we'll get to why and how Mr. Senior's phone was wiretapped when we look into the next case. That'll be coming, but as I said, 188 pages. So whole lot going on. I hope this has been sort of a good thing to whet your appetite for the main event here. I will tell you, that file is a little more complicated than I expected. I sort of went in expecting that it was going to be fairly cut and dry and that I'd be coming out of it going, hey, I got all the answers. I know exactly how I feel about this one. It's a little messier than that. So I'm kind of looking forward to going over it with you. Hopefully you guys are looking forward to it too. If you've enjoyed this, please like this video. Please share it with your friends. Subscribe to see more content. I also want to thank my Patreon supporters at the $50 level, Sir Daniel Wicks of Alberta, Jason Elliott, Canada's National Firearms Association, North Central Process Service, Kyle Martin, Jean-Guy Toussaint, Ivo Nedev, CCFR, BCAMF.org, as well as the Canadian Shooting Sports Association. At the $30 level, Sights and Arms Limited, and at the $20 level, Matt Ward, Mark Whittington, Dale Nesbitt, Cameron Johnson, Andrew Elsich, Adam Meester, Marc-Olivier Damour. And I also want to thank all of you at the $10 level who will be in the crawl immediately following. Thank you for watching. I hope this has armed you with knowledge, and see you next time.